Morning.
I'm Jonathan Turner. I'm from Williamson County. I'm here on a appeal out of a first-degree murder conviction in Bedford County that happened. This trial was July 24, but the offense happened in 2022. There's two main issues: a motion to suppress dealing with the DNA evidence match that was in the CODIS database, and the second issue is sufficiency of the evidence. I'll just go right into the facts of the motion to suppress the relevant information. The facts are really not disputed about about the motion to suppress. Basically, a hat was found with footprints near the murder scene at the end of the apartment complex, and two DNA samples were obtained from that hat. Upon a search of the CODIS database, a match on the appellant was made. The relevant fact is that the match was based on a 2009 arrest that he was acquitted of in 2012. So this is basically 10 years later, that DNA was still in.
I have a technical question. Okay, now, your client was later also arrested for other felony charges, right? But in those two, there was no DNA sample taken from him because he was already in the system? Or do you know the answer to that question?
I think the record is completely silent about that. There's no evidence that said that the DNA was collected or not collected.
Do you know procedurally how that works with law enforcement? In other words, if I've been arrested and my DNA is in the CODIS because of a felony arrest, and then later, 3 or 4 or 5 years later, I get arrested again because I'm already in the system, do they take my sample again? Or because I'm already in the system, they don't take it? Or do you know?
Well, my understanding is they would take the DNA sample and then do a search on the CODIS database to see if it matches or not.
Okay.
There's no way to match it without.
All right. And so you say there's nothing in the record with regard to the subsequent arrests, whether or not they took a DNA and put it in the CODIS system?
No, Your Honor, and I didn't do the motion to suppress.
I understand that. I just didn't know if you knew.
And I thought about that too, but there's absolutely nothing saying it was collected or matched or done anything based on that prior arrest. So our argument would be that's kind of a red herring because there's.
But statutorily, there was supposed to be, right?
Right. Correct.
Okay.
Correct, Your Honor.
All right. Thank you.
So, I mean, it sounds like though the DNA sample was still in the system when it was a 2017 arrest, somewhere around in there, the second one?
So it would have still been in there.
It would have still been in there.
Yes, Your Honor.
That's when the second arrest occurred.
Correct, Your Honor.
Okay.
And it was still in there for the murder matching in 2022.
Right.
So 10 years later, 10 years earlier, it was supposed to have been purged.
But wouldn't it have been taken though into 2017? Let's say it was purged. It was. And then when he was arrested in 17, wouldn't it have been taken then? So that it would have been there, I guess, so that it would have been there in 22 when he got this charge.
I don't disagree about that, Judge, but my argument would be that there's no evidence to suggest that they did take the DNA sample and that they did a CODIS search.
What was the charge in 17? I think you had that in your brief, but
I think he was charged later on, and then that was pending when the 2022 happened.
Okay.
So I think
I think it was aggravated assault and aggravated burglary, perhaps.
I think
in
so.
17.
In 17, yes.
Well, I don't want to get too far in this argument before I ask this question, because this is a relatively new. I don't know that I've ever seen this issue before on appeal. But the statute itself, 38-6-113, has provision in it under subsection C1 that says the detention, arrest, or conviction of a person based upon a database match or database information is not invalid if it is later determined that the specimens or samples were obtained or placed in the database by mistake. I think the state refers to that in their brief as a saving statute. Doesn't that answer this question? I mean, let's say it was mistakenly not taken out after he was acquitted in, 15 years ago. Isn't that kind of the answer of no harm, no foul, because it wasn't taken out and it was a mistake?
Your Honor, just to be clear on this statute, it says the samples were obtained or placed in the database by mistake. That's not what occurred here. This case was, we're not contesting that it was obtained by mistake or placed in by mistake. We're alleging that the statute of 4035-321, that it's supposed to be purged. But if you even look at the top of that saving statute, the first part of it, it specifically says that the TBI shall maintain, preserve, and analyze human biological specimens. Maintain, preserve, and analyze. And it goes on to say that it shall contain convicted felon profiles, forensic unknown profiles, criminal suspect profiles, and violent juvenile sexual offender profiles and missing person. Based on the 2012 dismissal, none of those applied to this case. It should not have been in there. Our argument would be that the TBI is not maintaining that database properly because they're allowing evidence to be DNA to retain when it shouldn't be, which begs the problem, you know, if they're relying on a saving statute, well, it needs to be clear. It doesn't apply to purging, but if this court doesn't put the onus on the TBI, and I'm going to go there, then there's no incentive for the TBI to maintain an accurate database on any level. They could just have, you get arrested, it's a felony, you're in there for life. What incentive would they have to purge it? There's probably no incentive at all. And we would submit that they're, based on that and the case law about whether this is a reasonable search or not, that it's not reasonable based on that. Your Honors, I forgot to reserve 5 minutes for my rebuttal. I apologize.
Can you? Yep. Okay. I think you're right. Go ahead.
I apologize, Your Honor.
I forgot to ask. I meant to too.
That's my fault, Your Honor. I do want to respond to some of the state's arguments. The state argues additionally that it's a good faith exception, even if it should have been purged. The response to that is that, you know, there's another case law about the state maintaining a trespass list, and they didn't maintain it properly in McElrath, and they determined that that was bad faith and that you got to show some sort of recklessness. Based on these facts that the TBI was taking no measures to ensure the database integrity of their CODIS system, that they're just recklessly engaged in maintaining this DNA. The state even cites a case where this happened in another incident. So this is not a one-time incident. This did happen before, and it's probably going to happen again if there's no safeguards or requirements that the TBI actually maintain a database that is actually valid and shows the integrity of the database.
And so how is the TBI to know that a case was dismissed?
Well, I think it's a very simple answer, Your Honor. They maintain the NCIC database. In this case, the officer from TBI actually did a search on the NCIC to verify whether the case was dismissed or not. So that process is there. There's nothing, this is 2025.
Did they not have to get a copy of some type of dismissal order from the court? Or
Well,
have a copy of something like that?
Your Honor, if it's dismissed, it should be uploaded to NCIC that the case was dismissed. Like if you do a diversion application, it would show that, things like that. And that there was nothing, I mean, in 2025, there's no reason why they can't automatically run a list against the NCIC to see if any of the matching DNA samples need to be purged or not. This is not difficult technology.
So the TBI agent who ran this DNA sample had also checked the NCIC and found that that 2012 conviction was dismissed.
Yes, Your Honor.
He or she was aware of that when they went further to see, well, let's see if there's a DNA sample in there.
Yes, Your Honor.
So the record indicates that he or she knew that it had been dismissed and should have been removed.
That's my understanding, that they did the NCIS, that they did the search and showed that it was dismissed, but it was still in the DNA, it was still in the database.
Okay.
And they matched it, and that led to you know, them finding all the other evidence against the appellant.
There was a case that was cited in, I think, the state's brief, Fields versus Tennessee, that came out this summer. And as I was reading the procedure on this, it looks like that the court clerks had the responsibility of notifying the TBI, who maintained the Tennessee CODIS entries. And then the TBI, then based upon the information they received about disposition of cases, then either makes the determination about it's expunged or dismissed to take it out of the system. Rather than, they don't do it, I don't think they do it through NCIC. That's a separate system.
Correct. Currently, that's the process.
Right, you said something about NCIC, and I just think the way I read what is in this opinion from this summer is that it's the clerks send it to the TBI.
That's currently what goes on now. If the clerks don't send in the information, then the TBI right now doesn't do anything.
They don't do anything because they don't know to.
Exactly.
All right, and in your situation, you have no idea whether the clerks sent it in and or if they sent it in for whatever reason it didn't get expunged.
My understanding from the record is the clerks never contacted the TBI.
They didn't send it in that particular case.
That's what the record
At least there's no,
reflects.
okay. So did somebody from the TBI come in and testify to that
Yes, they
in your
did.
case? And they said, we just don't have a record of it.
Correct.
Okay.
Our argument, though, would be that that case that decided by the state, that case was a PCR case, post-conviction relief, and they ruled that the lawyer was not ineffective. And one of the arguments the lawyer used was that this is a case of first impression, and he didn't really have any precedent. And
Right. And all I was trying to do was just confirm the procedure. So
Gotcha.
I'm not, yes, okay, thank
I
you.
think I only have 3 minutes left. I'm going to reserve the rest for rebuttal. Thank you, Your Honors.
General?
Good morning.
Good morning.
Please the court, Lacey Wilbur on behalf of the state. Your Honors, the defendant is not entitled to relief in this case. With respect to the first issue, and we didn't talk about sufficiencies for his oral argument, so I will rely on my brief for that issue unless this court has any questions on sufficiency. But with respect to the defendant's motion to suppress and dismiss the indictment because his DNA was in this DNA database, the trial court properly denied that motion. And Your Honors, this is exactly, there is a saving statute. It is new, but there is a saving statute that says if this DNA is in there, and it should not be, the conviction shall stand. So on that alone, the saving statute applies, and the trial court was correct in relying on it. And even if you're going to parse out those words saying it was placed in the database or obtained and put into the database, and that does not imply in this case, again, as you noted, the defendant was arrested in 2017 for 2 qualifying violent felonies, assault with strangulation and aggravated burglary. And so that would have put his DNA into the data bank at that point.
So do you know procedurally that when he was arrested, whether or not there was a sample taken?
There is no
and/or
testimony, Your Honor, in the
there's
record.
nothing in the record.
Correct,
say-
Your Honor.
Okay.
And again, I think it's because it's so new, we didn't really have templates on how to do this, but common sense dictates that his DNA was already in the database. They look at it, see the DNA is in the database, so they don't get a new DNA sample. But
In 2017.
in 2017, yes, Your Honor. And so again, his DNA was in the database. It was in there properly, and there was no bad faith on the officer's part. And again, as you noted, this is a database where when a defendant is acquitted or a charge is dismissed, the court clerk has to notify the TBI. So this is not bad action on the police, on the TBI. They are not required under this statute to go and look at the results of every single case in which
So the responsibility begins with the county clerk's office to send to the TBI some court order judgment that says this case was dismissed.
yes, the statute specifically says that the court clerk shall notify the TBI. And what we do have is the TBI agent who testified at the hearing. He said it usually takes 3 weeks for this to happen. I don't have anything in my records to show that that the TBI was ever contacted.
How do you respond to Mr. Turner's argument then what incentive does the TBI have to remove these when they legitimately should be removed? What if they can always rely on this saving statute that just says, "Oh, it was a mistake"?
I think if the court clerk had notified the TBI and that the DNA was still in the database, that would be a much harder argument. And then I would say that bad faith action and failure to take action would maybe not allow the DNA saving statute to apply. So yes, once the TBI is notified by the court clerk, TBI is required to take it out. And at that point, that onus rests on the TBI. We do not have that in this case.
Do you agree that this case is somewhat distinguishable from the Fields case from this past summer? I mean, that was in a post-conviction context that was alleging that as a claim, I believe, of ineffective assistance of counsel, that the lawyer did not notify the TBI that these.
The Fields case, as I remember it, is that this court ruled that trial counsel was not ineffective for raising the issue that his DNA was still in the database because the DNA saving statute would apply. And again, as it's so new, this is a case directly on point.
So you think that's directly on point with?
Well, with a context of PCR. But yes, this court has said it's not ineffective assistance of counsel for you to not have raised it because the DNA would have been in there anyway. And that's the part that's directly on point. The DNA would have been in there anyway.
Okay.
Regardless of whether it's the saving statute or the defendant's arrest in 2017, which is well before the time the defendant murdered the victim in this case. If there are no further questions on this issue, and your honors have no question about sufficiency, I'll cede the rest of my time, and I ask that you affirm the judgment of the trial court. Thank you.
General. Counsel?
I'm okay to go to what somebody else wants to do.
I'm going to be brief. As far as the saving statute, the state alleges that we're parsing out the words. Well, the words of a statute are important, and the words clearly say putting in the database. It has nothing to do, that saving statute, with purging. And our response to the Fields case is that this argument wasn't even raised in the Fields case about whether or not purging is even applicable in the saving statute. The saving statute is clear. Samples were obtained or placed in the database. Those words were intentionally put in there for a reason, and that is to cover misplaced DNA. It does not cover DNA that shouldn't be in there due to expungement. Otherwise, that language would be in there. The state hasn't responded to that in any meaningful way. And we would submit that the saving statute doesn't apply to this case. What does apply is that the saving statute specifically mentions that they need to maintain the database. And if the state is not maintaining a database of the integrity of the database, they're not really maintaining a database at all. And that's really not good policy. Even though the statute in 40, in the statute under actually having the clerks 40-35-321 notify the TBI, that's a completely different argument about whether or not they should maintain the DNA. The code section in 38 specifically applies to maintaining the CODIS DNA database, and we would submit that that takes precedence over whether or not, just because the clerks didn't notify, that that database should be expunged. And going back to the prior felony, to respond to the state's argument about whether or not that 2017 would have had it in the database no matter what, the record clearly is missing. There's no record. The TBI came in and said there was no record of the 2012 dismissal. Well, they also didn't testify to anything about whether or not there was a 2017 inquiry based on a DNA sample collected by the appellate. That certainly was, it was the burden of the state to prove that it was would have happened anyway, and they did fail on that proof. And we would submit that that's kind of a red herring because there's no evidence to suggest that a DNA sample was in fact collected and was in fact searched against CODIS. Finally, with the good faith exception, you know, the standard is whether or not it was reckless. Our argument would be that it's reckless to maintain a database that is not maintaining its integrity, especially when a conviction is still in there for 10 years and it shouldn't have been there in 10 years, and that is bad faith. And I'll just reserve any questions that your honors have.
Don't have any questions, but you took this case for appeal, correct?
Yes, Your Honor.
I want to thank you for that. I know I speak for all the judges here. We're struggling with that a little bit in some judicial districts of getting attorneys to handle appeals. And this particular judicial district is one of them. So I know we all appreciate your taking this appeal.
Thank you.
You didn't handle
you,
the
counsel.
trial, though, did you?
I wasn't there for the trial or the motion to suppress, Your Honor.
Thank you.
Thank you, Mr.
Thank you,
Turner.
Your Honor.
Good job by both sides. We'll
Mhm.
take it under advisement and get an opinion out shortly.
I'm okay.
Okay.
Would you call the next case, please?
Armand Yosef Hazuki versus